Please honorable court, David Burgess, currently representing Larry Lee.
Buckle up, folks, because what you're about to witness is one of those chaotic legal roller coasters where the drama isn't just about the charges, it's about the courtroom strategy unraveling in real time. Larry Lee, the defendant, kicks things off by trying to cut ties with his attorney. That's right, before we even get to the real meat of the case, the man's already switching gears, firing his lawyer and considering representing himself. And Judge Simpson, he's not playing around. This isn't some traffic ticket. We're talking about a serious criminal charge, criminal sexual conduct in the 4th degree. And yet, the defendant is flip-flopping between "I want a lawyer" and "I'll go solo." You can already feel the judge's patience wearing thin. And let's not ignore the tension in the room. You've got legal privilege questions, last-minute motions, and a judge walking a tightrope of professionalism and disbelief. If you're wondering how this courtroom is going to handle a defendant determined to represent himself, just wait. Things only get messier. Stay with us. It's about to get real.
Your name, sir? Clearly. All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted as well as this letter, I'm asking the court to allow me to withdraw as his counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only had a staff member relay them to me, were, I would say, privileged communication to the extent the privilege would still exist between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed that they were. That is what I presumed that they were. At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw. And basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in, I guess, inter-office mail or however it got to me, a letter from the defendant saying all kinds of different things.
This right here is a classic case of courtroom confusion. Larry sends in a letter saying he wants to represent himself only to walk that back minutes later and ask for new counsel. Talk about indecisive. Judge Simpson, trying to maintain order, shares the letter with both parties. But let's be honest, this flip-flopping doesn't just delay proceedings, it jeopardizes Larry's own defense. In criminal cases, especially serious ones like this, consistency and clarity are vital. If the defendant can't decide who should represent him, how can the court trust he's prepared to proceed? This isn't a minor delay, it could derail the entire process. Quick question for you. Would you trust someone to represent themselves in a serious criminal case if they can't even stick to one decision about counsel? Let us know in the comments. The tension's rising and Judge Simpson's about to get a crash course in babysitting legal chaos.
But indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also to Mr. Burgess in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. As far as I'm concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself? Or do you wish the court to sign an order that permits the Office of Manager Assigned Counsel to appoint counsel to represent you.
I would like the latter.
So you want new counsel.
Yes.
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time.
Yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Okay. I was unaware of that. Fact. Are we talking a 1 month or a 2 week adjournment? Just curious.
Well, it's wherever the court, I've got a very tight schedule, but we will. What day?
August 19th, Your Honor, would be the date.
It would go out approximately a month.
Okay. I have some upcoming surgeries. And so I will then like to just represent myself because I don't, they're very serious surgeries. And so I don't have the.
Larry drops a curveball. He wants to represent himself now because of, wait for it, upcoming surgeries. On one hand, you can sympathize with someone juggling medical issues. On the other, this isn't your typical delay excuse. He's literally trying to speed up a sexual misconduct case because his calendar's getting tight. This moment shines a spotlight on a dangerous legal misunderstanding. Representing yourself isn't a shortcut to a quicker trial. It's a gamble, especially in a case where the stakes are so high. And it's clear Judge Simpson is doing everything he can to give the defendant a chance while protecting the integrity of the process. If you think this sounds chaotic now, just wait. We haven't even started the examination yet.
Okay, but
Time to
right.
wait.
I understand that, but when do you think, if you represent yourself, when do you think your examination would be?
I would object to any further delays, and I would like as soon as possible, convenient with the court and everyone else. I'm prepared.
You're prepared to what?
I'm prepared to take the first available date for the examination as soon as possible.
Well, I don't know what you're asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just 2 pages of the interview with the detective and the victim. And I have reviewed
I'm
that.
going to probably believe that there's more than just 2
Correct.
pages.
Correct, Your Honor.
I just provided copies too, Judge, when he was at my office in May 8th.
So I would need copies of that.
I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself?
Let's pause right here. This is where Judge Simpson drops the hammer. He senses what we're all sensing. Larry isn't ready, not by a long shot. The man barely knows what evidence even exists in his case, and now he's saying he's fully prepared to conduct a legal examination solo. It's like watching someone walk into a lion's den in flip-flops thinking they'll win. Courtroom representation isn't a formality, it's a battlefield. And Larry Lee seems to have packed for a vacation. At this point, you have to wonder, is this really about speed or is it about control?
I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
So what do you want me to do, Mr. Lee?
I would like to proceed today.
Okay, you understand that it cannot finish today.
Sure. I agree. It's fine.
Would the people have a witness they can start with?
Your Honor, we have a witness we can start with. I will say for the record, I do have concerns that if Mr. Lee is going to be representing himself, he's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns from the people, but we do have a witness available if that's what the court is inclined to do.
Is that really what you want to do, Mr. Lee?
Yes,
I think you just, I'm gonna be honest with you, I think you're just telling me yes, thinking that you're gonna get a quicker date. And I am not clear that you're ready to go because you only talked about two pieces of paper and counsel's telling me there's a whole lot more in this file.
Judge Simpson doesn't just suspect manipulation, he calls it out. You can feel the tension tighten like a noose. Larry's strategy of saying yes to everything just to get an earlier date is completely transparent, and the judge sees right through it. This is one of those rare moments in court where the judge drops the formality and speaks like a human being, not just a legal authority, and it's refreshing, because it reminds the courtroom and us that behind the black robes and law books are people who can smell when something isn't right. Do you think Judge Simpson should have allowed Larry to represent himself here, or should he have forced legal counsel based on the confusion? Drop your thoughts below. It's a risky call, and we're about to see what it costs.
I understand. I'm willing and ready to go
Do you
today.
have a copy of the discovery?
My attorney hasn't provided me with a copy.
True, Judge. I gave it to him on May 8th. When he was at my office. He got a
Or the
copy.
2 pages, yes, that's what I have. The
No.
other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage. That again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage at.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr.
No. If you're, no.
Do you still? Mr. Wyman. Would the people be available? It is gonna be a mess on the afternoon of the 8th. It's a Friday.
Your Honor, I should be available. And I don't August 8th, Your Honor.
Yes, ma'am.
Yes, Your Honor.
All right. Are you gonna be able to, so if I set it on the 8th, sir, and I'm sort of pigeonhole you in on a Friday that I normally wouldn't hold them, but if I do the 8th, are you still wishing to represent yourself or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we were ready to proceed today. The victim is here in this visitor's waiting since this morning. Victim has also been here previously, ready for an exam. I would just ask that we have no further delays on the 8th.
Yeah, if I'm gonna be done, if you're saying, Mr. Lee, that you're representing yourself and I set this on a special date, I'm not going to at that time, if you wish an attorney, then I'll have to deal with that, but I'm not going to let a delay happen. Okay, we're gonna go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right, I'm just.
Double checking. Days works.
Pardon?
Days works for the people.
All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the 4th degree involving force or coercion. You understand that, sir?
Yes, sir.
Now we get into the gravity of the case. This isn't just legal gymnastics, we're talking about criminal sexual conduct involving force or coercion, a potential 2-year sentence, mandatory counseling, DNA samples, sex offender registration. This is where the weight of self-representation becomes clear. Larry's standing in front of a judge, hearing these charges read aloud, and still believes he can navigate this minefield without a trained attorney. And credit to Judge Simpson here, he outlines every possible consequence, gives every warning, and makes absolutely sure the defendant understands what he's walking into. That's the mark of a judge who's firm but fair. There's no comedy here, just cold, hard reality, and a defendant who still says, "Yes, sir."
And that involves a Stephen Kwanzi. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor, punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or have been taken upon your arrest. You understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that. You understand that if you proceed to represent yourself, you do so at great peril, and usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You
Yes.
understand that, sir? And you understand that you will not be, the court is not going to treat you worse, and not going to treat you better than any attorney or the prosecutor in the case. You will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
Your Honor, just for clarification, does the defendant want to stand by counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
This moment is gold. After insisting he's fully capable of defending himself, Larry throws in a last-minute request for standby counsel, if it's available. It's almost like he just remembered how serious things are. But standby counsel isn't some backup cheat code. It requires court approval, funding, and typically only comes into play when the court believes the defendant is truly prepared, but might need occasional legal lifelines. You can hear the quiet exasperation in Judge Simpson's voice. He's seen this pattern before, and he's drawing boundaries. If Larry wants to go solo, then solo it is. This isn't Burger King. You don't get it your way every time in court. Standby counsel is often a last resort safeguard, but courts won't automatically grant it, especially when the defendant's been all over the place with their requests, and we're not done yet.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this. I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
Bond violation will follow.
Yes, is that and the bond violation. Yes.
The defense is requesting, you to, examine the information between myself and my attorney, because I am alleging that I did not violate the, bond, the condition of the no contact order in my bond, and, witness tampering, that the prosecution says that I'm guilty of, and the text messages prove,
You're asking me to look at information that would be relevant to the bond hearing?
the text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, this is, and you're asking me to look at it in reference to the bond. violation.
Yes, because I think it should be reinstated.
I will address that on the 8th.
Okay, thank you.
Okay, I'm not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you. What I'm gonna do, and I realize I have 3 short matters, I'm gonna take a break, allow the press to break down, get themselves out, and then I'll come back out. Court is standing recess.
And that, folks, wraps up one of the most volatile pretrial hearings we've seen in a while. From firing his attorney to rehiring the idea of one, then back to solo defense with a maybe for standby counsel, Larry Lee's strategy, or lack thereof, has kept Judge Simpson on edge the entire time. But despite the back and forth, the judge held his ground, laid out the law clearly, and scheduled the examination for August 8th. The charges? Criminal sexual conduct in the 4th degree, with serious consequences on the line. Whether Larry sticks with self-representation or does another 180 remains to be seen. What we do know is this: if he continues on this path without proper legal preparation, he's heading straight into a courtroom disaster. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp, stay informed.